Welcome, and thank you for joining the Moncton Chambers and Near Economic Consulting second annual summer webinar series, Competition Law in the UK and EU. Today is our fourth and final session, Abuse of Dominance, a whistle-stop tour. If you were unable to attend any of our previous sessions, the recordings are posted to the event website. Before we get started, I would like to cover a few housekeeping items. All attendees will be muted. You will have the opportunity to submit text questions by typing them into the question and answer pane of your Zoom control panel, and we will aim to answer during the Q&A portion of today's webinar. If you have any technology issues, please use the Q&A box as well, and I will assist you. This session is being recorded. You will receive a follow-up email with a link to view the recording. We welcome you to revisit the content at any time and share it with colleagues. Lastly, the opinions expressed in this webinar are solely of the participants and do not reflect the opinions and beliefs of their organizations or affiliates unless expressed explicitly. And now, without further ado, it's my pleasure to turn it over to Josh Holmes, QC, barrister at Moncton Chambers.
Thank you very much, Pam, and welcome everyone today for joining what I hope will be a very interesting discussion. Our topic is abuse of dominance, and as I'm sure you'll all be aware, this is a tremendously dynamic area, particularly in the digital space. As Pam has said, my name is Josh Holmes and I'm a competition law barrister. We have a stellar panel to discuss our topic for today. I'm delighted to be joined by Dr. Jenny Haydock, who is a Director of Economics at the CMA, where she's currently involved in the CMA's digital work. She worked previously in economic consultancy on regulatory matters around the world. Also on the panel is Adrienne Severa-Jackson, who is an Associate Director of NERA, specializing in the economics of competition and digital markets. And Adrienne previously worked as a senior economist at Ofcom, the UK communications regulator. Daniel Beard, QC, is a leading barrister at the forefront of many of the biggest cases in the dominance area, including cases working for Google, the recent Royal Mail case, and the Intel litigation. Daniel also led the successful appeal for Apple on the state aid and tax issues. As a roadmap for today's presentation, we'll begin with a discussion of the proposals in relation to the establishment of a digital markets unit within the Competition and Markets Authority, the UK competition regulator, with particular input from Jenny. We'll then consider insights from other existing regulatory regimes, drawing on Adrienne's experience in the field. And Daniel will then give us an insight into key issues and developments in the case law from a legal perspective. And finally, we'll return to Adrienne, who will consider the Royal Mail judgment in which Daniel and I both participated as counsel to consider what light it sheds on the use of the as efficient competitor test. So without further ado, we'll turn to Jenny. And Jenny, would you be able just to launch us off to give us a brief introduction for the uninitiated into the proposals for the establishment of a digital markets unit?
Sure, of course. Thank you very much for that introduction, Josh, and it's great to be here today. So, as Josh mentioned, I work at the CMA as an economics director, and a lot of my work last year was as part of the Digital Markets Task Force. So this was a commission from the UK government that came in March last year, so a different world. And the government asked us to provide them with advice on how to deliver their objectives in the digital area in a proportionate and efficient way. And what this meant in practice is that we had to think about how to operationalize things like the proposals for ex-ante regulation of the biggest tech firms. So we were getting into things like processes and timetables and tests. And as far as I know, a lot of what we were doing hadn't really been done before at that level of detail. A major part of our proposals, and the part that's probably most relevant given today's topic, was the proposal for a regime that was focused on firms with so-called strategic market status, or SMS. So we proposed that those firms should face an enforceable code of conduct to prevent them exploiting or excluding consumers or other businesses. Also, the potential for pro-competitive interventions by the regulator, that would be to promote dynamic competition and innovation, and a modified merger control regime, including a lower standard of proof at phase 2. So that advice was published in December last year, and just last week, the government published a consultation document which was heavily informed by that advice, and which we hope is the next step towards legislation.
Thank you very much for that overview, Jenny. That's very helpful. I suppose the first question which springs to my mind is, what exactly is the relationship between this concept of the SMS firm and the traditional concept of dominance, which of course has featured as a key component of unilateral conduct control under ex post competition law? Is there any light you can shed on that for us?
Yes, so the short answer is that they are different tests. They're not the same thing. So the test that we proposed in our advice was that a firm would have SMS if it had substantial and entrenched market power, and the effects of that market power were likely to be particularly widespread and or significant. And that last part is what we described as a strategic position being enjoyed by the firm. Now, it seems likely that any assessment of whether a firm has substantial and entrenched market power would draw on a lot of the same evidence as an assessment of whether it has a dominant position. But that strategic bit is new, it's different. It's not obviously in the dominance test. So there's no real way of saying whether the SMS test is a higher or a lower bar than dominance. It's a different test. One thing I would note, though, is that I think most people envisage, myself included, that only a small number of firms would be found to have SMS. So given the current state of the world, if I had to guess, a small handful, perhaps. And that's different to dominance, very obviously. The other thing that's perhaps worth noting is that this substantial and entrenched market power, we proposed it be assessed across an activity as opposed to a formal antitrust market. This was quite deliberate. We wanted to avoid the regulator having to engage in a formal market definition exercise. We wanted it to be able to focus on the direct evidence of market power. So things like the substitutes, the alternatives that customers have, or the scope for entry and expansion by competitors. And also to be able to think about the ways in which different digital markets can be quite interconnected and the dynamic nature of competition. So we quite deliberately wanted to avoid that binary of deciding what's in and out of the market. So the definition of an activity that we put forward in our advice was such that, at least my personal opinion is, it could be wider, quite a lot wider potentially than a relevant antitrust market. But that was deliberate. And in that sort of vein, just one other observation from my time working on the task force is we did take into account quite carefully, when thinking about how to design an SMS test, this question of whether firms should be able to self-assess. So this is obviously something that comes up in dominance cases and in a lot of our work. Our feeling was that firms being able to self-assess about whether they had SMS was less important than it is in traditional ex post competition law. And the reason for that is because you have to have a SMS designation in place before any remedies are imposed. And that designation is itself a process that would be subject to consultation and probably appeal. So you don't have any obligations until you've been through that process. So we felt that this need for firms to be able to self-assess was slightly less important in this case than for ex post competition law. And we felt able to weigh quite heavily the need for the test to be flexible and future-proof, as well as obviously providing a clear justification for intervention.
And following on from that, does the fact that the focus is on activities rather than formally defined markets suggest that you might have several firms with SMS in relation to the same area of activity, or is it too early in the process to discuss, to sort of state a view on that?
I think Yeah, I think it's too early to say on that. We certainly envisaged that a single firm could have more than one activity that was designated. But the main focus here was, well, partly to give a focus to the DMU's work and its investigations, but also to make it clear that for a lot of these firms, we wouldn't expect the SMS status or most of the resulting interventions to apply to everything the firm does. Certainly not to apply automatically to everything the firm does, because as I say, we were very conscious that whatever test we had for SMS, it needed to provide a clear justification for the subsequent interventions. And so it was important that the DMU had to say what parts of the firm's business it was worrying about and define those, and therefore give some structure to the subsequent interventions.
Understood, that's very helpful. We've obviously heard from the European Commission quite a lot about the concept of gatekeepers in digital markets. And I wondered how the concept of SMS relates to that, insofar as that's yet a developed thing.
Yes, I mean, it remains to be seen whether the EC's gatekeepers will be the same as our SMS firms, but the tests are slightly different, so possibly not. But there are similarities between the two proposals, of course. Unlike the Commission, we don't have a sort of firm list of sectors that are definitely in scope or definitely therefore others being out of scope, and we didn't propose specific revenue or other size thresholds. We did talk about those things, and we suggested they might be things the DMU, the digital regulator, would look at in terms of its prioritization decisions, but we didn't feel they belonged in the test itself. For instance, and we talk about a firm being a gateway as something that the DMU might look at when it's thinking about whether it has strategic market status, whether it has a strategic position. But again, we didn't put that word gatekeeper, gateway into our proposed test. And one reason for that, well, partly because it's arguably not that well defined. People mean slightly different things when they use those terms. But also we were concerned that on at least some of the interpretations, it would restrict things to intermediaries. So to firms that provide, whose service means they put businesses in contact with consumers. And we didn't see any reason to restrict the SMS regime to those sorts of firms. So we kind of quite deliberately avoided using that terminology directly. But yes, it's not a million miles away, I suspect.
And following on from that, turning to conduct, do you see the proposed code of conduct as similar to the Commission's proposals for obligations for gatekeepers?
So, I mean, I'm by no means an expert on the Commission's proposals, but it seems to me that a difference, a potentially non-trivial difference, is that we proposed a bespoke set of rules for each activity and for each SMS firm. Our view was, well, we chose that option because we felt it offered better flexibility, and not just in terms of avoiding under-enforcement, also in terms of avoiding over-enforcement and helping with future-proofing, basically making sure that the rules were appropriate in every case. And, you know, others have written, and I mostly agree with that, about the important differences or potentially important differences between the business models and monetization strategies of various big tech firms. And we're very conscious of that. We were very conscious of that when we were writing our advice. All that said, I think it's very plausible that the outcomes of the two sets of proposals, what we're suggesting for the UK and what the EC is suggesting, will be to a large extent consistent. And I guess just one other sort of personal observation is, you know, there's obvious advantages to regulatory coherence, but personally, I'm quite interested to see how similar but slightly different approaches play out, because I think we should learn a lot about what works best.
A laboratory effect between the two regimes.
I mean, I don't think the entire European economies are a laboratory, but yeah, we might learn something.
Well, I suppose one final point on this topic before we widen it out, the million-dollar question. Why would you say ex-ante regulation was necessary at this particular juncture?
I mean, as you say, it is the million-dollar question. I mean, I think lots of the arguments are quite well rehearsed by now. You know, the idea that the existing tools are too slow, they're inherently backwards looking, any remedies they offer are one shot and case specific, and that you need ex ante regulation to sort of shape behaviour going forward. To some extent, for me, the slightly more interesting question is why now? You know, what's changed actually? Because I think if you'd asked me 7 years ago, say, do I think we need ex ante regulation for big tech firms? I'd probably have said no. And so it's interesting for me to think about, well, what has changed in my own mind? My reasoning 7 years ago would have been that the economic problems or issues that these firms throw up are the same. They're no different. They're not fundamentally different to the issues thrown up by non-digital firms. And therefore, we don't sort of need new tools. And I think that's true in the sense that I don't think there is new economics here. I think the economic tools we have probably are still good. You know, network effects, economies of scale, these aren't new concepts, right? They've been in textbooks for decades. So that's solid, I think. But what has changed for me is probably the certainty that there is a problem, and in particular, a problem that isn't going to be sorted out by the market on its own. And I think that changes things. I think if you're in a position as I was 7 years ago, I don't know why I'm particularly saying 7 years ago, let's say 5 to 10, there wasn't a great big revelation at some point, where you still think the market might self-correct, maybe competition really is just a click away, maybe the market will tip to somebody else next week, then you can see why you'd be reticent about sort of wading in with your big size 9s or even your petite size 5s and potentially making things, you know, worse, ruining things, messing things up. But I think that that sort of calculus changes once you accept that the market won't self-correct and that there really is a problem. Because I think then inaction, just the status quo, stops being a neutral choice. And I think at that point, you need to have just as high a bar for doing nothing as you have for intervention, where intervention might be, for example, developing an ex ante regime. And I don't think that a market being fast moving or complicated undermines that argument. Yes, a market that's fast moving might mean that if you intervene and get it wrong, it's a higher cost. But equally, if you don't intervene and that was the wrong choice, then that's also a higher cost. So the stakes are maybe higher, but I'm not sure it pushes you towards either action or inaction. And if the market's complicated, then arguably that's quite a good reason to have an expert regulator. So I think once you accept the market isn't going to self-correct, and also once you see the scale of the potential problems, and that's probably the other thing that's shifted a bit in the last 5 to 10 years, that some of these products and services have become so integral to everyday life. I think at that point, it's difficult to argue that the existing tools are adequate, you know, that a years-long Competition Act investigation would solve the problem, or that anything fundamentally backwards looking will do the job. And that's not to say the existing tools will be rendered obsolete, assuming we get this new regime. It's just that for the SMS firms, at least, there will be an additional complementary tool.
Well, thank you very much for that overview. Before we widen this out and bring in Adrian to discuss the other existing regulatory regimes which overlap with ex post competition law and the concept of dominance and abuse, is there anything anyone else on the panel would like to ask Jenny or to raise in relation to the DMU proposals?
The only question I had was, we talk about the interesting issue of competition between regulators in the UK and regulators in the EU on these sorts of issues, because obviously we're focusing on a divergence to some extent from the way that we've operated over the past 20, 30 years. But how does the CMA look at the changes that are going on under the new administration in the US as essentially a third pole of kind of regulatory competition, where we know that the US comes at these things traditionally with a very different outlook from perhaps EU and previously UK case law? But on the other hand, there are changes in mood in the US.
I don't think I'm in a position to speak for the CMA as a whole there. I mean, personally, I think it's super interesting. And it's, as you say, it is sort of a third pole there. And I think it remains to be seen how much of the current proposals actually make it all the way to law. But that process in itself will be interesting. And some of the private actions over there are obviously, just going to say interesting again, but they are. And but for sure, it seems like the mood music has changed quite dramatically and is perhaps somewhat more in line with what the prevailing thinking on this side of the Atlantic as well.
Very interesting. Well, Adrian, could I turn to you now? And I know you've done quite a bit of work in the telecoms sphere, and with the concept of significant market power, SMP, which has been used there, and also the remedies that have been applied successfully in relation to telecoms. Would you be able to just introduce us to some of the experiences and learnings in that field?
Yes, of course. Thank you very much, Josh. And thanks, Jenny, for a really interesting overview of the CMA's thinking on these issues. So yeah, in this section, I just wanted to share some possible insights from other regulatory regimes, specifically telecoms first, and then a bit later, broadcasting. So firstly, what can we learn from the telecoms regulatory regime? I wanted to briefly cover 2 points. Firstly, how relevant is the concept of significant market power, or SMP, in thinking about the threshold for regulatory intervention in online markets? And second, the use of pro-competitive interventions in telecoms. So as we heard from Jenny, the CMA's advice identifies strategic market status, or SMS, as the threshold for intervening in digital markets. Many of the features that lead to SMP in telecoms markets also exist in digital markets. As Jenny mentioned, for example, economies of scale, network effects, and vertical integration. And also some of the criteria that are used to assess whether telecoms operators have SMP are also likely to be relevant for assessing SMS. So some examples include, for instance, the existence of vertical integration and the ability for a digital firm to leverage market power from its core market to foreclose rivals in other parts of its ecosystem, or the strength and type of network effects generated by the digital platform and a degree of multi-homing by users across different platforms, and also access to infrastructure that might be difficult to replicate, like data sets or customer bases. But as Jenny also alluded to, while there are similarities between telecoms and online markets, there are also differences that limit the extent of read across from the telecoms framework to the new digital regime. For example, in telecoms, you have natural monopolies with fixed physical networks that were previously state-owned businesses, while digital platforms' market power is often derived from collecting vast quantities of user data, which can sometimes give them a competitive advantage. Also in telecoms, incumbents typically leverage market power from the upstream network level into downstream markets within the same supply chain, the same vertical supply chain. Whereas digital platforms can use data to extend market power across a broader range of adjacent or complementary markets within their ecosystem. And in terms of remedies, Ofcom has intervened many times to promote greater competition in telecoms markets, for example, by mandating wholesale network access to first promote retail level competition and then infrastructure-based competition, or also by imposing obligations to give access on FRAND terms, or even by enforcing functional separation, as they did between BT and Openreach. Now, the Digital Markets Unit would also have the powers to impose pro-competitive interventions, specifically to address the sources of substantial and entrenched market power in digital markets, potentially using extensive remedies like personal data mobility or third-party data access, or even separation remedies. So I wanted to ask Jenny, to what extent would you say that the DMU proposals were informed by other existing regulatory regimes in the UK or overseas?
Thanks, Adrian. That was really, really interesting. And yeah, you make some really good points there. So we certainly thought a lot about other regulatory regimes when we were preparing our advice. In fact, we had secondees from Ofcom and the ICO on the task force, and we learned a huge amount from their experience and expertise. I mean, ultimately, we were trying to create something new. I mean, the DMU will be unlike any other regulator because, well, it's not a sector regulator in a meaningful sense because digital isn't a sector. And so, we couldn't read across directly, as you suggest, but there was still a lot to learn from experience, including on things like processes and timetables and, how you set these things up in practice. So Ofcom and the ICO were obviously very important. Also, we thought about Ofgem, and I think we also mentioned the Groceries Code Adjudicator at one point as well. So we really did try to learn from those experiences, definitely.
Thanks, Jenny. So the other point I wanted to cover briefly was the interaction between different regulatory goals. So when regulating digital markets, there might potentially be multiple policy objectives to balance. So not just protecting competition, but maybe also protecting consumer privacy or data protection, or even in some cases, perhaps media plurality, or even protection from harmful content. And so the DMU and indeed other regulators may in some cases need to consider and weigh up these different goals before intervening in digital markets. And in fact, the government consultation that Jenny referred to earlier specifically is consulting on whether the DMU should be given powers to take into account wider policy issues that might interact with purely competition in digital markets, as well as whether the DMU should have a duty to consult and cooperate with other regulators. And so I just wanted to briefly talk about an interesting example of an existing regulatory regime that does have multiple policy objectives. And that's the regulatory framework governing the BBC in the UK, which requires Ofcom to balance two public policy goals that might not align. So on the one hand, they have to enable the BBC to achieve its public service remit and deliver public value to audiences. But on the other hand, they must protect competition in the areas where the BBC operates. This regulatory framework is quite high level, and the detailed implementation falls to Ofcom. So firstly, why does Ofcom regulate the BBC's impact on competition? Well, the BBC does make a valuable contribution to people's lives in the UK and plays a vital role in the public service broadcasting system. But it inevitably has an impact on competition in the media marketplace because the BBC is license funded and it doesn't need to make a commercial return. And so there's a risk that it might take audiences away from commercial rivals and potentially undermine their incentives to invest. And these two opposing effects can move together. So the more the BBC expands, for example, by launching a new TV channel, say, the more public value it could generate and the more private and social benefits it could create. But at the same time, the greater the risk it could crowd out commercial investment, and this could affect competition. And so weighing up these different effects involves regulatory judgment. And in this regime, Ofcom has discretion in how it balances these two aims. Now, economic analysis can help with this balancing exercise, for example, by linking different effects to tangible consumer or citizen outcomes, like choice, quality, or innovation, so that these different effects can be measured and compared. And Ofcom can assess whether consumers are better or worse off overall if the BBC expands. So when regulating digital markets, regulators might need to weigh up the interaction between, for example, both competition and data protection. And those objectives may be aligned or indeed potentially in tension, as was discussed in last week's fascinating webinar on privacy for those that were able to dial in. And this relationship is also explained in the CMA and the ICO's recent joint statement on competition and data protection. So Jenny, how do you see the DMU proposals as they currently stand? How do you see them interacting with other regulatory regimes and objectives?
Thanks, Adrian. And I love the BBC example. I think it's fascinating. And as you say, there's been some recent publications in this area. So when we were coming up with the task force advice last year, the close working between the DMU and other regulators was a key part of our thinking and of that advice. As I've mentioned, digital isn't a sector, and therefore we should expect that the DMU's work will bump up against and interact with that of other regulators. So I think you've mentioned already that we now have the Digital Regulation Cooperation Forum, the DRCF, which brings together the CMA and Ofcom and the ICO and now also the FCA. And this is all about regulatory coherence and information sharing and so on. The DRCF published an annual plan for those that are interested back in March. And you've also mentioned, Adrian, the May report, joint report from the CMA and the ICO. I also commend people the recording of last week's webinar if you're interested in this area. Tom Reynolds, who leads the economics at the ICO, made some very interesting points about the complementarity of competition and privacy objectives. So I think that's, for those that are interested, a really good place to start. I mean, there is a debate about how a digital regulator would, or indeed even if it should, take into account considerations other than competition, such as data protection and privacy. I mean, of course, well, I say of course, nothing's of course really in this area, but in my mind, of course, the DMU should be looking to improve objectives through competition. It's a pro-competition regulatory regime. That's what it says on the cover, and that's the ambition, as I understand it, of the government. But the idea the DMU should sort of be willfully blind to other issues like data protection would be very, very odd. So the question is really just how those other concerns are incorporated into the DMU's objectives and remit. And as you say, Adrian, the government's consulting on this, but one can imagine the DMU having a duty to consult other regulators or a duty to have regard to certain concerns other than competition. And this isn't just about managing conflicts between different aims or different priorities. It's, I think, also about allowing the regulator to take a holistic view, particularly probably in remedy design, to make sure they're doing something that is pro-competition but doesn't sort of trample on other concerns as well. So at least from what I've seen, this is definitely an area that the CMA and the work we're doing in the context of the shadow DMU, which has been established within the CMA, is very committed to, working closely with colleagues from other bodies, sharing thinking and expertise, with the ultimate ambition that the DMU can work effectively and efficiently.
Well, thanks, Jenny.
That was fascinating. Thank you both. So one question that it prompted in my mind was that when one considers the regulatory regimes that Adrian was discussing, in some ways the regulators have had it somewhat easier, at least until relatively recently, because they were dealing with largely domestic businesses operating at national level. I appreciate that in broadcasting there's a significant shift that's occurring now. But of course, I imagine the work of the DMU will be looking at players that are global in their reach and activities. Do you think that presents any challenges in terms of the feasibility of the DMU's potential activities? Jenny and Adrian, I don't know if you have any thoughts to bring to bear on that, or do you think it can work just as well despite the different scale of operations of the regulated entities?
I think it definitely presents a challenge for sure. And there are legal questions in there that I'm definitely not qualified to opine on. But international cooperation, and not just cooperation between UK regulators, was also something that we considered, and something that the shadow DMU team are very aware of and are working on right now. I mean, as I said earlier, regulatory coherence across countries would seem to make sense. And certainly if we think about the UK and the EU, we talked earlier about some of the nuanced differences between the proposals, but really the ultimate aims and the concerns that are driving these proposals are extremely similar. So I would hope that we can converge on solutions that work across the piece, but I don't think you could sit here and say it isn't a challenge. Adrian?
Yeah, thanks for the question, Josh. Yeah, I mean, I think I would echo broadly what Jenny said there, that the importance of international cooperation will be really important, I think. And as you say, a consistent regulatory approach is probably going to be needed to tackle what are essentially concerns that arise at a more global level. And just in the same way as the DRCF, Digital Regulatory Cooperation Forum in the UK, is seeking to deliver a more coherent, consistent approach to regulation of digital in the UK. It'll be interesting to see the extent to which similar initiatives can be taken forward at international level.
In that vein, actually, there was some recent work at the G7 level, I understand it, to try to improve coherence on digital issues. So that's something to watch out for as well, I think.
Yes, indeed. Daniel, I don't know if you have anything you'd like to contribute to this stage of the discussion, or if you'd like to move directly to the case law on abuse of dominance, which I suppose is the other piece for today's discussion.
Yeah, I think the observations being made about global cooperation are all laudable. I think it's quite interesting thinking about how that's going to work in practice. After all, different states have vastly different interests. If one looks at other areas where global cooperation is widely praised and very difficult to execute, for instance, in relation to tax field, we can immediately begin to see how there might be differential approaches between, say, the US and the EU, UK, particularly if what we're talking about here are potentially the US-based streaming services who are developing significant presence worldwide, and quite how remedial powers might work on a geographical basis is going to be one of those very difficult and, as Jenny rightly puts it, interesting challenges, not just for the UK, but for the EU as well, and presumably also for some of the Asian or Australasian regulators who are dealing with these problems as well. So it's not unique, and it's going to be a struggle, but I think we need to be cautious about how sanguine we can be that we'll all take a beautiful, harmonious view, hold hands and go skipping into the regulatory sunset together on these sorts of issues. But anyway, I've been asked to talk about case law, and I'm supposed to be giving insights into key issues and developments in relation to dominance. And the difficulty I have is I'm not quite sure what those are in relation to any of the cases we're dealing with at the moment. So I'm going to start by massively delimiting what I talk about, because that makes it marginally easier. So I'm going to focus on pricing issues in relation to abuse of dominance, but even that isn't narrow enough for my limited scope. And I'm actually going to be focusing on exclusionary pricing practices, so not excessive pricing practices. Obviously, we've seen a bunch of case law actually in the UK, where the UK authorities have sort of led the way on excessive pricing practices, that in those circumstances, we have developed case law that has assisted across the EU and is being looked at worldwide. I'm going to look at some of the exclusionary pricing practice issues that arise, in particular in relation to European cases, but also in relation to the eponymous case that leads the seminar, the Whistl case. So let's start with a couple of pretty banal observations about exclusionary pricing practices and how they work from the point of view of abuse of dominance. We've essentially got two questions we're asking ourselves. What's the legal test we're applying here? And what's the sort of evidence that one can use in order to meet that legal test as a regulator? Or what can you challenge as someone accused of abusive pricing practices? On what basis? So if we start with the legal test, I think it's worth just taking a quick step back to what we saw in some of the Intel litigation as summing up the position, because I think it's important not to lose sight of the fact that one of the key insights we now have in relation to 102 pricing practice cases is that you really do have to look at all the circumstances. Of course, there was a strand of European case law that said, well, you can look at the form of the pricing arrangements. Are they exclusivity discounts that you're applying as your pricing methodology? If they are, then they are to be treated as abusive. And Intel, I think, probably helps us as being part of a development of case law, not only in relation to 102, but 101 in cases like Carte Bancaire, which says actually one needs to think much more about overall effects and look at all the circumstances, not just put things in boxes and apply labels. But we also know that the basic legal test that's applied in this context is a rather generalized one, in the sense that it talks about whether or not a dominant undertaking is using methods that are outside the scope of normal competition, and using methods that are other than those that are part of competition on the merits. And of course, one of the difficulties one then has is what is constituted by competition on the merits when we're talking about pricing practices. And again, we do get some instruction, albeit not unambiguous instruction, from the way that the Grand Chamber and Intel approach these matters, because it emphasized, of course, that it must be borne in mind that the purpose of 102 isn't to prevent someone on their own merits acquiring a dominant position, nor is it sentimental, 102. It recognizes that competitors who are less efficient than a dominant undertaking may well struggle to remain in the market. And it cites cases like Post Denmark and so on. So this is not novel case law. And then it also emphasized the fact that that means that not every exclusionary effect, in particular by pricing practice, is necessarily detrimental to competition. That competition on the merits may just by definition mean that you get departures from the market of less efficient competitors. Again, no objection to that. And of course, what we see in that language is the reference to the efficiency of the competitor with whom you're dealing. Now, I should just pause at that point and emphasize that in all of this discussion, I think it's probably consensus that you can have situations where competition is improved by allowing or encouraging less efficient competitors into a market. There's no doubt that that can occur, and there can be well-documented circumstances where it's positively useful. I'm not sure that's necessarily the key question, though, for the purposes of 102, because what you're asking yourself is what it is that someone shouldn't be doing and can be penalized for doing. In other words, as Jenny was referring to earlier, it's an ex post prohibition. And even if ex ante, you may have a policy that says, I want to improve competition, I want to encourage less efficient competitors. The question arises whether or not that is a relevant legal test for 102. And I think the question is posed in Intel, and I'm not sure it is completely answered. And of course, Intel is not a complete piece of litigation yet, because we have had the Grand Chamber talking about these issues in general terms. And of course, there are ambiguities in what it says in the judgment, and we are still awaiting the outcome of the general court revisiting that in Intel and working out how those principles apply in the case they were developed in. The hearing was, oral hearing was over a year ago, beginning of the first lockdown, and we still wait with bated breath to see what the general court has said about it. But I think that takes us neatly onto the Whistl case, which concerned Royal Mail. Royal Mail, who obviously is dominant in the supply of postal services at all sorts of levels across the UK. But in particular, it is dominant in providing what's called bulk mail services. In other words, where you're a local authority or you're a mail aggregator and you pull together lots and lots of post for lots and lots of people across the country, or in particular regions of the country, you can sort it out, purchase services from Royal Mail, and they will do some degree of sortation and then end up delivering the mail for you. Now, Royal Mail had various prices that it would, or price plans that it offered in relation to those bulk mail services, but it decided that it wanted to change the prices that it offered for two particular price plans. It wanted to introduce a differential between those price plans. Now, the first of those price plans said, look, if you're a bulk mail operator and you're going to give us lots of mail, we'll give you one price if you broadly give us mail in approximately the same proportions as we deliver our ordinary mail. And then it said, but if you don't do that, if you give us much more patchy bulk mail, you exclude certain areas, then we're going to charge you more for your bulk mail services. That was the proposal. Now, on its face, most people might think, well, there might be good reasons for that. But this change was undertaken or proposed in the context of a new rival coming along, Whistl, which, although it is part of a very big mail distribution entity, had come up with a decision to run a business actually to do the final mile delivery in cities. In other words, it was going to run a fresh postal service in central London and Manchester and various other places. where there was sufficient density. Now, of course, if you are going to do that, you're going to deliver your own mail, you don't need to use Royal Mail's bulk mail services for those regions. Of course, as soon as you stop wanting to use Royal Mail's bulk mail services for those regions, then the overall spread of mail that you're wanting delivered is not necessarily mirroring that of Royal Mail, and you move on to the second price plan that was being proposed, and that price plan was more expensive. And what was said by Ofcom in its decision was essentially, look, you Royal Mail have structured this price differential such that you essentially stymie the development of this entrant in these circumstances. And since they're your only entrant and only competitor in relation to what's called end-to-end delivery, then in those circumstances, that's a pretty serious issue. And we consider this to amount to abuse of dominance. We're going to impose a fine. Royal Mail, needless to say, wasn't vastly happy about it and appealed that matter to the CAT. In doing so, what it said was, amongst various other things, that the pricing that was being offered, even under the second plan that was more expensive, still allowed an as efficient competitor to compete with Royal Mail in relation to all aspects of the delivery process. Now, Ofcom, in its decision, had said, we don't think that this sort of AEC as efficient competitor analysis is really that relevant. We don't think you've done it right, but mostly we don't think it's that relevant in these circumstances. And the Competition Appeal Tribunal agreed and said, look, AEC tests might be useful in margin squeeze cases and other places. They might even be relevant in relation to the sort of conditional discounting situation that was occurred in relation to Intel, but you're not mandated to take these issues into account as a regulator. And actually, we can see real reasons here why actually an as efficient competitor couldn't emerge, and using this test doesn't really reflect what's going on with a competitor entering the market. Now, again, Royal Mail, not vastly happy with the conclusion of the Competition Appeal Tribunal, took it up to the Court of Appeal, but the Court of Appeal very clearly upheld the CAT's decision, saying that there was no reason to consider that an AEC analysis or AEC evidence was particularly relevant or necessary to be taken into account, and that Ofcom or the CAT had failed in their way of dealing with these issues. Now, there's a limit to how far we can take this discussion, because there's been an application to take these matters up on further appeal to the Supreme Court. But one can see that this is a case where this use of a technical test is being emphasized. And of course, it goes to two aspects, going back to what I said about there being a legal test and an evidential threshold. In part, what it's saying is, well, what's the legal test here in relation to whether or not pricing is abusive? If it's the case that a less efficient competitor would be excluded, but an as efficient competitor could continue to compete at a certain pricing level, what's the problem with that, having reference to those sort of broad principles that Intel articulated? But it also goes to the question of what evidence is relevant. Is it relevant in these circumstances to take into account what you think you, as the dominant undertaking, consider to be a profitable level at which to price? And the reason I put it in those terms is because, of course, the AEC test, as Adrienne will come on to talk about, is actually focused on what it is that the dominant undertaking knows. It's focused on the dominant undertaking's costs and whether or not it prices in such a way as to make a profit. And the reason that might be important goes back to a point that Jenny was referring to earlier, which is the degree to which you're setting a test and relying on evidence that engenders a degree of legal certainty. Now, critics of the AEC test will say, yeah, but each component of this test are terribly complicated. Where's the legal certainty in arguing about whether or not these are average avoidable costs or lyric costs or some kind of variant on these costs, and what your profitability is and how the various metrics are to be calculated? That isn't legal certainty in any world that I know about it as a lawyer. But nonetheless, I think for many companies, it's actually the sort of exercise that they consider relatively regularly when they're thinking about pricing. And therefore, although this case law to date, in particular in relation to Whistl, is saying this material is not necessarily relevant to a question of abuse, the importance of carrying out AEC analysis for companies that are dominant and thinking about pricing practices will potentially continue to be relevant. And we're seeing that issue aired not only in relation to the postal market, which was what was in Whistl, nor just in relation to the chips market, which was relevant in Intel, but we're seeing it particularly in relation to digital markets where entities may be said to be dominant. We're seeing these issues being aired in the appeals being led by Google in relation to the infringement found in relation to Android and its AdSense technologies. The Android case is going to be heard in September. And we've also seen it in particular in relation to Qualcomm, where there were allegations of exclusionary abuse, where Qualcomm said that it had put forward relevant economic evidence that was akin to an AEC test. And the Commission said it was not persuasive, not relevant, and was a matter that has been the subject of a relatively recent oral hearing, and we're awaiting the outcome in relation to that. So as I said at the outset, I don't know the answers to any of these issues, and I'm not even sure what the key developments are at the moment. But nonetheless, we are in territory in relation to dominance issues where there is a range of considerations, both in relation to the test and the evidence that's relevant, which are highly pertinent to industries where we see dominant undertakings emerging. Thank you.
Thank you very much indeed, Daniel. It was very helpful. I think given the time, we'll move straight to Adrian, who will discuss the what next for the AEC test in light of Royal Mail and how the test might be applied. I think, Adrian, would you like to introduce the topic and then we can consider it in a little more detail? I should also say, if anyone has any questions, do please use the question and answer function, and we'll try and answer them in the dying minutes of the session. Adrian, over to you.
Thank you, Josh, and thanks very much, Daniel, for a really good overview of the Royal Mail case and the Court of Appeal's recent judgment. I just wanted to briefly touch on what it means for the importance and then the role of the as efficient competitor test in dominance cases going forward. So I'll make a couple of preliminary points first. I mean, the AEC test is still a useful tool for assessing exclusionary conduct in many cases, alongside other evidence, of course. But in certain circumstances, the test may not be appropriate or relevant. And this might be due to market features or the specific pricing practice in question. So the AEC test is helpful for distinguishing between legitimate and harmful pricing when you're assessing low prices, like predatory pricing or margin squeeze, but it's not well suited to test for high or excessive pricing. And as Daniel outlined, in Royal Mail, the concern was about a price differential that involved a higher wholesale price that was targeted at a potential entrant to deter them from entering and expanding. So it was a form of raising rivals' cost strategy. And secondly, the AEC test is likely to be less relevant where the incumbent firm has very high market shares or where it enjoys structural advantages, like having a national network, or where it's an unavoidable trading partner. So that was sort of by way of introduction. Josh, I can move on to.
Yes, it would be interesting, I think, if you could just consider the guidance that emerges from the Court of Appeal judgment. That was a helpful overview, but how do you see the lay of the land based on what the Court of Appeal had to say in Royal Mail?
Thanks, Josh. So some of these points have been covered by Dan, but I'll just very briefly recap them. The Court of Appeal's judgment helpfully provided some guidance on when and how to apply the AEC test in different settings. And it set out in particular 6 propositions. So I'll very briefly skip through those. So firstly, competition authorities don't need to carry out a test to conclude that a pricing practice is abusive. And while the test can be useful for determining abusive conduct, it isn't always relevant, including in the situations that I mentioned where, for instance, the dominant firm has a very large market share or has structural advantages that essentially make it practically impossible for an as efficient rival to emerge. Thirdly, and importantly, the AC test, when it is used, has to reflect economic reality by using costs that an efficient competitor would actually incur. So you can't simply apply a formula based only on the dominant firm's prices and costs if that doesn't match the reality. If a competition authority relies on the AEC test, the dominant firm can challenge the authority's methodology and conclusions, and the courts have to engage with those criticisms. And as I'll touch on a little bit later, there are lots of practical complexities in applying this test. And where the dominant firm itself relies on the test to argue that its conduct is not abusive, the authority and the courts have to engage with that evidence too. But in any case, even if the test supports the dominant firm's argument, so even if the dominant firm can show that an as efficient rival would not be foreclosed, this evidence could well be outweighed by other factors. And competition law doesn't really specify how much weight should be given to this test. It's down to the judgment of the authority or the court. And so it's important that the test, when carried out, is done in a robust manner.
Thank you, Adrian. Given the time, I think we'll have to leave the second part on the practical implementation of the AC test. And I'd like just to give a moment to each of the panelists for any final thoughts, beginning with Jenny.
Thanks, Josh. Yeah, this has been such an interesting panel, and I think in particular helping me to gen up on the latest developments of these exclusionary pricing abuses, which I've not been involved in recently, so that's great to get. But also tying together, I think, some of the issues that cut across this, and the fact that, the fact that we can have a session on the digital markets unit and digital regulation in a session that's about dominance, I think tells us that there are interactions there. And thank you for the questions and observations, which I think will definitely give me some food for thought going forwards.
Very good. Daniel, do you have any final thoughts?
Like Jenny, I think the interaction between these different schemes is interesting. We're seeing clear developments of the use of data and analysis in competition law and the use of economics in tests in things like AEC, which are improving our understanding of effects. At the same time, we're seeing those very issues of the power of data and the power of economics telling us that we have problems in relation to dominance. That conglomeration of issues and problems makes the interaction between the new tools and the old tools particularly interesting, but it does give rise to real uncertainties for those that are operating in the market who still want to understand what it is they can lawfully do and when they can do it, particularly under the ex post prohibitions.
And Adrian, any final comments?
Yes, thanks, Josh. I mean, just briefly, as a sort of forward look, there are a number of ex post competition investigations into the digital platforms ongoing at the moment. And of course, if any of those are infringement decisions, there'll always be the potential for follow-on damages claims. And it's interesting to sort of think through the differences between how you might assess the harm suffered as a result of an abuse of dominance versus how you might estimate, for example, the damage arising from a cartel case. And in a dominance setting, I think, given particularly if a rival is foreclosed, it's important to think about, what is the forward-looking impact of that foreclosure, not just on the rival, but on consumers going forward. So it's very much, a dynamic assessment that needs to think about the counterfactual, how things would have evolved absent the abuse, and the interplay between the efficiency of the rival now and how efficient a rival could have become had it not been foreclosed.
Thank you very much, everyone, for joining us. It's been a fantastic session. I think we could have talked for another hour easily around these topics. There have been a couple of audience questions which we'll pick up in writing. I'm sorry we haven't had time to come to them. All that remains to say is thank you very much to the panel and to the audience for joining. Good afternoon.
Thank you.
Again,
Thank you.
yes,
Thank you.
to all of our panelists. And thank you to the audience for joining us today for our fourth and final session. Again, you can listen to or you can watch previous recordings by going to the event website. And for those of you that we did not answer your questions live, we will follow up in email after this webinar. We appreciate any feedback you have to offer. So please fill out the survey that will appear in your browser. And on behalf of Moncton Chambers and Mira Economic Consulting, thank you again for joining us and enjoy the rest of your day.